allow me to share the regulations as well.
Yes, 1 second.
I believe that my screen is visible.
Yes, it is visible.
Nitika, hello, Nitika.
Yes, sir.
Nitika, may I request if we can have this as we discussed twice a week, if possible?
Sir, actually, I discussed it internally, but since the flyer has already been out, so it would be a little difficult for us. So anyway, 4 or 5 meetings are left, so we'll try to do it like this only. Maybe next time consider your
irritation होती है. मैंने एक plain बात करी, तो irritation होके बढ़ गया.
Before starting, I'll request all the participants to keep themselves on mute, so as to ignore any unnecessary disturbance in between. And of course, after taking regulations serially, we will allow the participants to have their to share their views as well on the respective regulations. To start with the liquidation regulation, last Wednesday we discussed regarding some of the issues or concern that we basically face at the time of liquidation proceedings of a company. And based on the suggestion of the respective members, this time we have started, or we have thought of starting regulation wise instead of focusing on particular issues. Pradeep sir, I'll request you to kindly mute yourself, sir.
You please mute to everyone.
तुम गोल्ड फादर हो. I am
वर्षा जी आप भी म्यूट कर सकते हैं.
मैडम आप ही म्यूट कर दीजिए सबको.
Barsha ji, you are also on mute now. So you can unmute yourself. Thank you.
Yes, I believe I'm audible now.
Yes.
Okay, so let us start regulation wise. Short title and commencement, I don't think so that there is any concern in the short title and commencement part. So let us start with the definition part directly. In the definitions part, the concern that I have find out is about liquidation cost. As to what should be included in the liquidation cost should be more clear. As to one particular concern which is here is about interim finance, interest on interim finance. If we see this particular part, subclause 6, which says that interest on interim finance for a period of 12 months or for a period from the liquidation commencement date till repayment, whichever is lower. So the timeline is stringent and may discourage interim finance. I'm not sure as to who all have during liquidation proceedings got the interim finance, but still if there is a possibility of getting interim finance during liquidation process, so this may be a discouraging part for the financer. So this part may be changed, or this may be changed accordingly, either a period of 24 months or whichever, instead of whichever is lower, whichever is higher can be inserted herein. And one more observation is with respect to the penalty cost. I believe that all the professionals must have seen the penalty part in the insolvency professional regulations as well. In the IP regulations, it is specifically mentioned that any penalty which will be charged, which will be occurred during the resolution or liquidation process, will be charged directly from the professional and will not form part of the liquidation cost. So first of all, that raised a concern about the liquidator's conduct itself, as to what if at all the penalty will be paid out of the pocket of the liquidator, then it will raise a huge concern on each and every activity of the liquidator. So a clarification in that regard is also required. Apart from this, if anyone else has any suggestion in the definition part or in the liquidation cost part, may please raise them.
Ma'am, I will request one request. Just participants are writing the chat messages and it pops out. So we don't read. When it's quite often it is popping out. If you can stop it, ask them to stop.
Sure.
There is
So
no
it is
need for
humble
this
request
message.
to all the participants, please don't ping your membership ID, etc. You have logged in and accordingly ICSI IIP has taken note of the same and your attendance will be accordingly recorded by them. So please don't ping your ID or your attendance here. Instead of that, let us clean this chat box with the queries and concerns only.
Thank you.
So let us start with this definition part now. So if at all anybody has any further suggestion on this definition part, that is most welcome.
Yeah, Barsha, in my view, there should be a point that interim finance period shall be concluded when the distribution of the sale proceeds occurred. Because interim finance, who will provide the interim finance shall have the first right on their capital and interest. So in spite of 12 months or from the period of liquidation date till the repayment of interim finance, it should be mentioned that interim finance for a period of with capital interest till the disbursement of the amount, till the
Yes,
receipt
so
of the
some
amount.
kind of, yes, of course. So the basic idea is to provide some kind of attraction to the respective finances so that it will be easier to get the finance during liquidation, in such liquidation wherein there is a lack of fund or fund is required. So idea behind this is that only. So yes, accordingly, this particular sub-regulation 6 requires necessary amendment.
Also a cost for maintenance of records should also be included here, you know.
Which otherwise also is included only, sir, which will form part of the cost incurred by the liquidator for preserving and protecting the assets of the property, etc. So this will be included here in only. So that even if not specifically mentioned, but will be included and will form part of this only. Is there any other suggestion? If no one has suggestion in this particular part, then we can proceed ahead with the next regulation, which is about contribution to liquidation cost. Here, one part that we have observed is that in the illustration, it is provided that financial creditors will be called upon to contribute as under. This, instead of financial creditors, there should be secured creditors, as in the liquidation, there is no bifurcation between financial creditors or operational creditors. Instead, it is secured or unsecured creditor. So it should be secured creditors here. And also, like if the probability.
Why you want to leave the unsecured creditors? They are also going to take the money. Any fellow who is going to take the money should contribute for the liquidation. He cannot be left over.
So you're not very audible. Can you please just repeat again?
You want instead of financial creditor, secured creditor. Even the unsecured creditor is going to get the money in liquidation. So all rank equally. In their equal proportion, they may have to contribute for the liquidation.
Because here one concern also arises is that the probability of any payment to the lower classes of the hierarchy mentioned in section 53 is very low. The liquidation process which has been concluded till now, it has been seen that only the first priority creditors have been paid, and that too they have to take haircut on that part only. And when there is a concern of financial creditors or government entities or operational creditors or other unsecured creditors, etc., workmen apart from this 12 months, 24 months due, so the probability of any payment to them is very low. So when there is no probability of making payment to them, how can we ask them to contribute further for this?
Then they file their claims and rank us and go to NCLT and even up to Supreme Court to claim that they have the top priority. When government claims are all treated as top priority, why not they contribute to the liquidation cost? They must do it. When you rank, you must do. I'm asking only the proportionate.
Like what you are saying is correct, but practically, if you see, it will be difficult from asking the operational creditors or workmen or government to contribute. If you see the hierarchy wise, so this will make the process more complicated. When it comes to first priority creditors, at least the liquidator has a hold of first priority creditors.
At least in cases where the other creditors are going to get their dues, then they should contribute to the liquidation cost. Wherever there is no chance of getting the due, then okay, they may be left out. What I'm referring to is other than financial creditors.
In cases where the secured creditors are not there, in that case, putting the word secured creditor only, in that case, the other nobody will contribute. So putting the word of secured creditor will exclude the other creditors, which will be a practical difficulty. So as far as the wording is concerned, it should be creditors in proportion to their eligibility as per section 53. That will be a better provision. Whoever is getting, they should be responsible for making the contribution as well. This is my view.
Anybody else has any other view on this?
Yeah, see, here it is written, 1, 2, 3, third line, it says the liquidator shall call upon the financial creditors being financial institutions. So if we are making these changes, even this has to be changed. It cannot be only financial institutions.
Ma'am, where the liquidation is, initiated at the instance of the operational creditor, and there are no financial creditor or other secured creditors, who will meet the liquidation cost? And
So
who is going
either-
to contribute?
So either we can make, or either the changes can be done in such a way that secured financial creditor can be included at first instances, and thereafter
No, my
clarification can be given.
suggestion is, ma'am, my suggestion is it should be not a creditor, it should be a stakeholder. Whosoever has the stakeholder who has initiated the liquidation process, he has to contribute, whether it is operational creditor or anybody else.
So you are saying that the applicant has to contribute?
No,
Yeah. Because if the applicant is operational creditor and you are using the word secured, unsecured creditors and this, so then he will who will meet the contribution cost? There are certain essential contribution costs. You have to proceed with the preferential transaction cases. You have to make public announcement. You have to process the claims. Everything is there. Progress reports are to be sent. Who will meet the contribution cost in that case? So there should be a provision that the applicant, at least the special mention of secured, unsecured will not serve the purpose. Even OCs driven liquidations will have problem in that case.
Because sir, if we compare this with the CIRP regulation, in CIRP as well, it is clarified that if there is a circumstance where there are no financial creditor, then operational creditors will form the committee. Simultaneously, or in the same manner, in the liquidation as well, say suppose there are no financial creditor, then operational creditor will lead. And the expenses also has to be borne by the operational creditor. Like in the CIRP regulation, the clarity is provided that what will happen when there are no financial creditor. Operational creditor will form the committee. On the similar line, if we can give clarification.
Yes, it should be very clear, because I am running a liquidation. It is at the instance of the applicant is operational creditor, and he is not no liquidation cost is decided. I have incurred cost. There is nobody to contribute.
Actually, the stakeholders who are all forming part of the stakeholders.
Because the idea behind the same is that only that if say suppose there are no financial creditor, then of course the probability of any payment to the operational creditors increases. But say suppose there are financial creditors, then of course there are secured creditors, then there is no question of any payment to the operational creditors, and you are asking them to contribute, or you are asking workmen or government to contribute. How
No. I am just
circumstances you will get any contribution?
No, my point is that in the absence of financial creditor or secured creditors or unsecured creditors, if the liquidation is initiated at the instance of the OC, there should be provision that OC has to contribute the cost of for the cost of liquidation.
So you are
we
saying
can make it bifold. One is where secured creditors are there, they will contribute. In the absence of secured creditors, then whoever is the operational creditor remaining, they have to contribute.
Absolutely. So the same,
Yeah.
I believe that if the same can be made in line with the CIRP regulations, wherein the clarity is provided that if there are no financial creditor, then how COC will be formed. In the similar line, this can also be amended.
Yeah, that's right.
Yes, it should be clarified.
Madam, where there are no financial creditors in the stakeholders consultative committee, the operational creditors have to contribute. That should be made clear, because in the present regulations, there is nothing about operational creditors. The stakeholders committee will consist, supposing there is no financial creditor, who will contribute. Operational creditors have to contribute, but that is not
Yes.
mentioned in the regulations. That has to be made clear.
Right, sir. So that is what we have also discussed, that clarity in that regard should be provided.
Yes.
As to if there are no financial creditor, then who should contribute towards this liquidation cost? Who should bear the liquidation cost? Coming to the next.
Madam,
One more thing.
Hello.
Supposing any financial creditor or operational creditor is not willing to finance, they should be taken out of the stakeholders
Yes, yes.
consultation committee. Some such provision should be there, so that they will be forced to either pay or get out of the committee. Get out as a stakeholder.
Workmen may be excluded from the burden of.
Yeah,
bearing
workman
the
may be there. Workman
bearing
may
the
be there.
I mean, expenditure. Because they
Especially
have
the,
already told,
especially
they'll
the
not be able
government
to-
departments, they have huge claims, but they simply refuse to contribute anything. And when financial creditors are there, or there are only one or two financial creditors with small claims, we cannot force them to contribute high amounts. So either there should be proportionate contribution from all stakeholders, or if financial creditors are not there, operational creditors have to contribute.
In light of rainbow judgment also, now that all the government organizations are saying that we are also secured creditors, so we should particularly include here that it has to be secured creditors, so that even the government contributes to the liquidation costs. They can't be recipients always.
Exactly.
In that regard, ma'am, already discussion is going on. I believe you might have seen the
Yes.
discussion paper of IBBI.
Yes,
Wherein the
yes.
suggestion has been made not to include the government tax as a secure creditor. So that is yet to be concluded, because of course that will have a huge impact on the ongoing proceedings, because in the ongoing matters as well, the liquidators are receiving claims from the government, claiming themselves to be secure creditor, specifically in that matter wherein distribution has already been done and the matter is pending merely because of the pending proceedings before the bench. So this is.
Hello.
Yes, sir.
Hello, madam. Actually,
Yes.
they are putting the pressure on the operation creditors. They give liquidation cost. They are suffering. There are so many cases in the MSME sector, and they don't have money to run their operations, and they are fighting for this, their money. I think for operation creditor, the government have a lot of money, and they have to make a fund for the IBPI. If they put 100 crore or 500 crore there for liquidation cost, if they people have no money, so at least they can finance, they can give some seed money to the liquidator. After that, if he will require, he will reimburse to the IBI. Na? So they are big, when we are making the big liquidation and this for the sustainable of economy of India. So government come forward and put 1,000 crore fund. There is no problem as such, I think. Why we are gonna putting this operation creditor? They don't have money and fighting for their money, and we use the liquidation cost. Oh, what is this?
Madam,
Yes.
my name is
Yes.
Madam, my name is Satya Devi. See, the preamble says that there is going to be an alteration in the order of priority of government dues, and therefore, as suggested by you through the bill, through the modifications, I don't think that government department should be given priority at all. So in which case, payment of contribution of cost by government does not arise. Already there is a good provision saying that financial institutions should do it. In the absence of financial institutions, the next priority, if it is defined, that is sufficient as per my opinion.
All right, ma'am. So let us proceed with the next regulation, which is regulation 2B, which is compromise or arrangement. I'm not sure as to practically who all have this compromise or arrangement implemented during the liquidation procedure, because the timeline provided is very unlikely and is impossible to meet. And in fact, the procedure to be followed during liquidation process is also not very clear in this particular regulation. So those who have practically experienced this compromise or arrangement during the liquidation process may please share their views, because in our view or in our observation, this particular regulations should not be there. So others may please give their views as to if at all they have any challenges or if at all they have faced.
This is correct, madam. This thing is a non-starter and it is best removed. This is absolutely non-starter. And many of the things that they have now put in as an afterthought, since things like, conducting a COC meeting as the SCC meeting within 7 days, discussing agendas and stuff like that. Those are also highly impractical things. So this one definitely needs to go. So does the thing of sale as a going concern. It's again a very, if it is a sale as a going concern, what assets? Because they say, you have to say asset and liability. So what liability will you sell? And if a resolution plan type is supposed to come, then what liability, if they meet part of the liability, who will meet the rest of the liability?
So basically, you're talking about the undertaking terms, sir, because in normal parlance, it has been seen that in the scheme of arrangement, what goes is undertaking. So an undertaking constitutes both assets and liabilities. When it comes to liquidation process, what are the assets? Of course, that is clear to us. However, when it comes to liability,
what will you
surely none of the acquirer will be ready to take these huge liabilities of any of the corporate.
Absolutely. That's exactly what I'm saying.
And then again, this compromise or arrangement part, in the discussion paper, the timeline is proposed to further reduce the timeline to 30 days, which is of course not yet been implemented. But
it is already reduced, madam. It was from 90 to 30 done, and now 30 itself is very short, and normally it doesn't materialize. It has to be done away with. It is better. It is very cumbersome and law conditions are there. Those conditionalities can never be met.
This and other thing like sale as a going concern. I don't know.
Because if the idea is to revive the company only, then of course the entire resolution process is there, and thereafter during liquidation as well, the going concern process is there.
No, but going concern process, see, going concern process again, when you do a sale as a going concern, let's look at two things. When you are saying sale as a going concern, it says that the liquidator with the consultation of the COC or the SCC should separate the asset and the liability. Asset and the liability to be sold as a going concern, right? Now, if you are doing that, liability is what? The entire claims and whatever there would be in the books, that is the liability of the company. Asset would have highly reduced value. So what liability? Also, where will the money go? Will the buyer pay the money directly to the creditors as per his choice, or the money will come into the liquidation account and be distributed as per Section 53 waterfall mechanism? So this whole concept of selling it as a going concern, the company in liquidation, is a fiction, is a legal fiction, neither feasible in neither
impractical, totally impractical.
Neither provided clearly in the Act, IBC, nor provided in company law.
So the proposal basically in this part is either to done away with this particular regulation completely, or to provide the detailed clarity as to what process or what steps should be followed when there is a compromise or arrangement during liquidation process. So as to make it clear to the liquidator as well as to how this timeline of 90 days can be practically implemented.
Yeah, because if you look at 230 compromise, you are supposed to have meetings of all categories of creditors and all those things.
Creditors and then shareholders as well.
Shareholders
So when it comes
as
to
well.
liquidation, am I required to take consent of shareholders as well?
Precisely.
So
Precisely.
there are several concerns, of course, when it comes to compromise or arrangement, clarity of which is not provided, and hence we are of the view that this particular regulation should be done away.
And you could say the same thing for liquidation as a going concern, ma'am. It was a fiction.
Now coming to the next regulation, which is regulation 3, eligibility for appointment of as liquidator. I personally do not find any particular changes or requirement of any changes in this regulation. However, if other members have any view on this, may please discuss.
Can you show the full section?
Yes.
Madam, sometimes say the creditors are going for OTS or action under SARFAESI. In that case, then how will the liquidator get his fees?
So can you please just repeat again?
Say when the financial creditors go for the SARFAESI action and thereby they dispose the assets and regularize the dues, then how will the liquidator get his fees? What are the rules regarding the payment of his fees?
How that part is concerned with the eligibility of the liquidator. Means I am unable to sync the query with the particular regulation as to if at all it pertains to this regulation part or not.
So this is basically you're talking about eligibility to appoint as a liquidator. So this is
Appointment and the
B?
remuneration of liquidator. No, so I am covering this point, this query.
I'm coming next to the remuneration part, sir. Just allow me a minute. Yes. So this is the eligibility part and coming next to the remuneration part as well.
One minute, please. Madam, I have a doubt here. See, when I am a partner of IPE, am I eligible to take any other case in my individual capacity as an RP for smaller cases? That doubt I have. See, I'm a partner of an...
If you are a designated partner of a IPE, then your own IPE LLP agreement or
if it allows,
whatever may not allow you.
No, if it allows, can I take up?
If it allows, you can, but you cannot hire the same IPE for this thing, no?
No, I was told it is a gray area. If they allow, am I eligible to take up? That doubt I have.
If your LLP allows, then you are. There
If
is
there
no
is
bar in the
no bar therein, then in our view as well, there should not be any restriction on appointment.
But you cannot be a director or partner with 2 LLP. That is clear.
That is true. No, I'm not confused in that manner.
No, madam, you can undertake assignment on your individual basis, provided there is an agreement between you and the LLP partner. That working agreement will be there. It will be clear in the working agreement. That permits.
Yeah, that's right.
Yes, so those ratios will be there. You can do it.
Yeah.
There is no bar on that. Yes.
Okay.
Coming to the next regulation, which is about liquidators fee, and I am sure that many may have concern regarding this liquidators fee part or may have faced difficulty when it comes to counting the liquidator fee. So yes, just allow me a second, ma'am. Yes, I believe the regulation is clear now. This particular part is visible to all. Yes.
Yes.
Madam, can I tell something?
Yes, sir. Yes, sir, please.
I am handling one case where there are no assets at all. The payment to liquidator is based on the sale of assets. Now, how to get my fees? That is an issue. There is only one person, and the stakeholders committee has got some powers to fix. But on what basis they will fix, and if they don't support, what will happen? There is no provision for any payment of a monthly payment or any lump sum payment when assets are not there for disposal.
I believe, sir, there are several cases wherein there are no assets in the company. In fact, the erstwhile the directors of the corporate debtor, promoters of the corporate debtors are also not cooperating. In those cases, it has been seen that NCLT particularly directs as to how much fees and who will pay the fees of the liquidator. I'm not sure as to how practically it is implementing or how it is happening in practical.
Can I just
Yes, sir, please.
see, basically, if there is no assets, what are you going to liquidate?
No, even
supposing if you know that there is no asset, and let's say there is nothing pending, nothing really pending.
Yeah,
Okay.
that is let me answer this question.
Yeah.
See, I am handling a case, practically same thing. There are no assets, but I have filed Section 66 application and it is going on. And I have filed 19(2) application against the directors for non-corporate that is going on. And I am doing it for the last three and a half years. I have been doing all this paperwork and quarterly progress reports and all that. And how to recover money, I see.
Sir,
So
practically,
If there are no assets, then the provision should be that it should be closed. Liquidation should be closed. But there is no provision for closing. It is going on.
Sir, what could have been done in this case? What could have been done in one of an case we are doing that. Of course, it's taken a time. Around a year it went, and we have also not recovered any fee in that because the lender simply says nahi dega. Okay, there's only one PUFE going on. So what we have done, we have filed an IA, dissolution IA, in the NCLT, saying that this is the situation. You please direct the creditors to pursue the PUFE application. Take assignment and pursue the PUFE application because they are not paying my fee, and also direct them to reimburse the cost I have incurred so far.
We cannot say they are not paying the fees. How will you claim the fee? On what basis you will claim?
No, so
there is no provision for claiming from the creditors directly.
Sir. There is a provision. No? So if you were the RP of this case,
I was not RP.
So
I am liquidator.
But it was appointed by what? NCLT?
Yes.
But you got the case from NCLT as a liquidator.
Yes.
Then go to NCLT for direction.
NCLT, where they are giving direction?
No, you have to tell.
If I can assist
See, what
here,
I am saying is that is a separate thing. Whether NCLT is giving direction or not is a different issue. But the regulation should have some provision. That is what I mean.
Yeah, that is true.
So please,
Madam, just like CIRP, Madam, I have to say something. Just like CIRP, there should be some guideline.
Exactly.
The idea basically here is that only to have the necessary implementation in the regulation itself.
Exactly.
Where the clarity is not provided as to what will happen in the cases when there are no cooperation from the corporate debtor, or there are no asset liabilities, or there are no such information available, what to do at that time. So clarity should be provided here that if an appointment is made by the NCLT, then the fees should also be decided by the NCLT in the cases where there are no assets or liabilities or such.
That's right.
So given that the regulation already provides, then if it is initiated by the COC, the liquidation process is initiated by the COC, then COC will decide, or else consultation committee will decide. But it is not provided that when the appointment is happened by the NCLT, then who will decide? So clarification in that line should be there in the regulation in order to provide the clarity.
I would like to add up something. If you look into section 1, clause 1, which says that you have to concentrate on 39D, which talks about this liquidation clause. If you look into the liquidation clause, particular cost, okay, when the COC wanted to liquidate the company, it is to be mentioned. It is a mandatory clause, which is one of the provision in your liquidation application, wherein you will state that the COC decided to go for a liquidation, on which as rightly mentioned, the present resolution applicant, resolution professional is not interested to continue as a liquidator. Point number 1. If such be the case, the COC decided not to appoint anybody, so NCLT can appoint somebody. Liquidation cost should also be discussed in that particular meeting. See, it is explicitly clear. The only problem is like none of us are applying it while going for the liquidation, because 39D of CIRP process very clearly defines about this.
I know, but let me.
Because, ma'am, practically
sir,
it has
I am
also
not
been
second.
seen.
I am also in line with you. What I'm trying to say that, see, so many areas we are also reading, we are doing a plain reading rather than understanding it in a proper way. They have done it meticulously. The only thing is like these kind of discussions will help us to understand the provisions in a better way. It is not only for you. Lot of people like us also doing the same mistake with the belief like NCLT will fix the cost. If you look into some of the cases, most of the cases in NCLT Chennai, they are saying the moment IRP is appointed, they themselves state that 2 lakhs rupees should be fixed as the expenses of the IRP.
That is
and the
also.
operational creditor or a financial, whomever it may be, they have to pay for the process to continue. Same way, whomever be the RP should have done it, and that should be part, if you look into it, part of the order. Okay, your case, as the other person very clearly said, you can go for a dissolution because you don't have a choice. But if there is a PUF transaction wherein you are going to continue as a liquidator, definitely SEC members should certainly give you a liberty. They should fix you the fees. They should also fix the fees of the advocate, because you cannot do a lot of things by yourself. You require an advocate to represent you, interact with you, do a conference with you. I mean, I completely agree with the speaker. And also there should be a clarity, but certain clarities are there. More clarity is required. This is my point of view.
I agree with you, but only one small addition. What you told, I fully agree, except that in my case, before this 39D or 13 whatever came into force, before that company went into liquidation. So COC did not have to consider any expenses part. Now liquidation has been ordered. It is PUF transaction is there. Of course, I have formed a stakeholders consultation committee. But on what basis we can ask stakeholders consultative committee to fix a payment is a question. That is why I am suggesting, like in CRP monthly payment, some fixing is there. Here in the liquidation regulations, some regulation should be there. Based on that, we can claim.
Yes, I agree.
Sir, all are willing to give some monthly remuneration, provided that they are asking us to set it off against the scheduled remuneration. In my case, there is a claim for 300 crores from 4 secured financial creditors, but all assets are under dispute with it is an infrastructure project with no tangible assets, all intangible assets. We can neither leave that nor pursue that. So it has become a litigation. We don't know whether we will be able to get it from the government. We are not sure of it, but we have our own merits. But it takes a very long time. The secured creditor is saying you take whatever you want, you fix some fee, but you have to set it off against the scheduled fee. We don't know if you will realize the scheduled fee or we don't realize. These problems are there. It is not that there will be work only if the assets are there.
But ma'am, that is a good thing.
It is very difficult to bring an end to say that there are no assets. I'm finding those litigations a lot.
Yeah, exactly. That is why
good. That is
struggling
good.
with that account.
That is why whether assets are there or not there, some fixed fee should be payable to the liquidator.
Some fixed fee should be payable in such cases. Yes.
Yeah, it should be included in the regulation itself.
Sir, it's my humble suggestion to all my fellows friends that while taking the assignment, one should study the corporate debtor first. Right? Before
but from NCLT, you just land up getting no sir.
Tell me, sir.
Before quoting anything, you should study the case. Then if you are becoming RP to liquidator, then at the last COC, you should mention everything, that otherwise don't take the assignment.
Yeah, it is easy.
Sir, you are probably talking about the assignments wherein it is proposed or you have received a consent or you have been asked to provide a consent letter for acting as a liquidator or RP.
Yes.
But there are instances wherein the appointment is happening directly from the panel.
Exactly,
And in
exactly.
fact, the respective professional is not even aware that his or her name is proposed to be to act as a liquidator in a particular manner.
Same,
And in
same
that,
thing.
वर्षा जी ये बताएं मेरे को कि पैनल में all cases are coming through NCLT and these are the dump case. 99% are the dump case which are going to the panel IPs.
you are correct,
Whatever,
but again,
whatever
the thing
case
is
it
that
may be, whatever case it may be, NCLT has given the
NCLT has to
liquidation
fix some
assignment to
fees.
an IP. The IP should
Apart
be
from
paid or
Then
not.
move an application and take confirmation from the NCLT.
No,
You
here
are
the
appointing
only
me.
concern
You are
is that
appointing me.
once you file
that
an
is another
application with
option.
the NCLT,
But what I am suggesting, there should be some regulation in the liquidation regulation itself, so that we can claim based on that.
What age there?
Otherwise,
But I mean, in some cases, the financial creditors or secured creditors are going for the surface action. And how about the liquidator's fees? How can he recover?
sorry, sir.
Say in some cases, wherever there are assets, the secured creditors are going for a surface action. Then in that case,
invoking section 52, sir. Invoking section 52.
Is it pursuant to invocation of section 52 you're talking about, sir?
Yes.
So what are the issue you are facing, sir, pursuant to that?
They say that the fees will not be paid because they are realizing the assets on their own.
No, they have to pay your fees. Okay.
Already regulations are there. They have to contribute the liquidation cost.
It is already included in the regulation itself.
That is right, but how is the fees fixed in that case? Just on the lines of CRP regulations?
No, you see, if there, let's say you have this chart, right? You have this chart.
Yes.
Now, under section 52, if they are invoking the asset, they will require your permission first. Before giving the permission, you will claim CIRP cost, which includes your fee. You will also make them pay proportionate share if there is any workman due standing in that company, because workman has first pari passu charge with the secured creditor, right?
Yes.
So that you have to take. So they have to pay that upfront and then take their asset to sell. Now it is also clear that in 180 days, if they are not able to sell the asset, it will automatically revert back to the liquidation estate.
Yes.
Okay, so this is pretty clear. You don't give the permission only before they pay. In one of my case, they did and wanted to invoke 52. I put my foot down, they paid, and then I gave it.
So I believe that let us focus on this regulation 52 after completing these regulations.
I think we are
particular...
sorry to interrupt. I think what sir had suggested earlier, there should be a provision for payment of to the liquidator. I think we should note down his suggestion.
Yes, sir, we are noting down the suggestions. Of
yes, that is correct.
Professionals. We are noting down this. So ideally, basically, the concern which has arisen is in this particular regulation is because of this this may, which is inserted in subregulation 1A, which says that where no fees is fixed pursuant to subregulation 1, the consultation committee may fix the fees of the liquidator. So here may gives a right to the consultation committee to fix or may not fix the fees of the liquidator. So again, for the cases wherein appointment is done directly by the NCLT, there should be a clarification. A clarification should be inserted as to how the fees of the respective regulator will be determined here.
Here also, the may can be fixed, replaced by shall. It should be may should be replaced by shall.
No, because if say suppose the consultation committee is not determining, if say suppose then this chart is there, then payment has to be made in terms of this chart.
Yeah, it should be remaining the minimum charges will be this.
Yes.
So,
as per the chart.
substituted with shall, referring to the General Clauses Act. We are all fully aware of the General Clauses Act, where the may shall be substituted with the shall, or where he shall be substituted with the he. All those things are available in the General Clauses Act. So there is no need to debate on this. They can
So-
fix it. That is the main thing.
We can take it in this manner that either COC has to decide. If COC is not deciding, then consultation committee can decide or may decide. If consultation committee is not deciding, then fees has to be paid in terms of this chart. However,
as per table,
in
yeah.
the circumstances where there is the appointment is done by the NCLT directly, and the probability of any realization from the assets, available assets, is very low. In that case, at the time of appointment itself, the adjudicating authority should decide as to who should pay the fees and how the fee has to be paid, because the bare minimum process has to be followed by the liquidator, which of course will cost time of the liquidator, the respective professionals, and this respective professional should accordingly be paid off for the job done by the respective professional.
No, before suggesting anything, kindly look Form H. When you are proposing a liquidation, you are supposed to file the Form H. In that Form H, you have to say how the liquidation will be funded, whether X is the liquidator or Y is the liquidator, or NCLT appoints the liquidator. The Form H will tell. So you have to go back to Form H and say, see what is really happening. With what terms the COC has agreed for the liquidation.
And one more small suggestion from my side. We have collected, we have realized assets, sold assets, and realized a huge amount up to 10 to 15 crores. And we have set it apart for the PF fund. In which case we are not able to take any fees on that 15 crores because we are still under dispute whether it forms part of liquidation estate or it does not form part of liquidation estate. So I want that also, that asset, even if it does not form part of liquidation estate, if any asset sold, it should be covered under this schedule. That is my suggestion, because in all my liquidation cases, I got a huge cut because of this PF payment. So whatever
asset which is not forming part of the liquidation estate, then how come the liquidator is responsible for realizing those assets, ma'am?
We are only selling all the assets, but there is a contention by many courts saying that amount of arrears payable to PF department does not form part of liquidation estate.
Yes.
It has to be treated like that. But all the work only we are doing. We are selling, we are doing e-auction, we are taking all steps to protect. So I think that asset also should be included here for fees part. Other part,
And you
I'm
are
not
talking about the Provident Fund?
Yes.
Provident Fund is completely excluded from the liquidation estate, and liquidator has nothing to do with the same.
But we are only selling all the assets, is it not? We are
How
only
you
doing all
selling
the
the Provident Fund part? It's not bit
No,
clear to
no,
me.
no. See, I'm not talking of Provident Fund asset. What I'm saying is the assets of the corporate debtor, we are selling the entire assets. And we are retaining that claim part of PF department separately, which is under dispute, whether it forms part of liquidation estate or not liquidation estate. That is a different contention. Let us not go to that. But fees part, we are not able to get any fees on that 10 crores set apart for this purpose.
Ma'am, sorry to
Yes,
disturb
sir.
you. Kindly see the clarification. You are realizing the assets, na?
Yes.
Then you are entitled for the commission as per the chart.
Even
Right.
in respect of dues
Yes, that's
payable
a
to
secondary
PF.
thing. See, distribution is the secondary thing. First, you have realized, then you are entitled for the commission, whether it is for that amount for PF or as per the section 53. That's a different thing.
No, sir, it is specifically said that commission is payable only on the liquidation estate, assets of the liquidation estate. It's specifically said like that.
Ma'am, that is the liquidation state only. Whatever assets you have realized, it's for the liquidation state only.
Yeah, this is pretty much.
Madam, here you are
Yes.
saying that you are
Liquidation
having
state
to
only.
pay the
Yes.
PF claim
Yeah.
out of the sale of asset. There was no separate PF fund.
Yeah, that is right. That is
available.
under
That is right.
contention. That is
the-
under contention. Let us not go
One
to
second.
that.
No, I'm saying
Hmm.
if there is a PF claim,
Hmm.
The claim is for what? Unpaid PF dues, or that is people have deducted and not deposited in the PF.
Yes.
So that means there is no fund in the PF.
Yes.
Now the recent NCLAT judgment and then Supreme Court judgment, everything says that the PF has to be paid in full, irrespective of whether there is a separate fund available for PF or no. Okay. So now you have this X amount of assets which you are selling, and you are realizing there is no separate fund which is kept for PF, right?
Yes.
You are realizing the asset. So when you have
Yes.
realized the asset, you are definitely entitled to your realization fee.
Okay.
And in my view, when you are distributing to PF also, you are there is no PF money from PF that you are taking. You are rather selling the asset and giving the money to the PF towards its due as per law. So on that, I think you are very well within your right to take even distribution fee also.
Okay, sir.
Yes, yes, absolutely.
Sir, I have difference of opinion here.
Yeah, please.
Then judgments, what they have said is the dues are beyond, I mean, it is much higher to even 53. So liquidation cost is under 53. So how will she take the proceeds which have to be paid?
Madam. Here it is like this. PF dues, let's look at it this way. PF dues means if there were some PF trust amount lying somewhere in the corporate data, that PF trust amount you could not have taken as a part of the liquidation estate. That was the thing. So if some PF money which has been deducted but not deposited, so that is the default. Now there is no separate fund available. You are not saying to the PF authority that whatever amount you give it, it is part of my liquidation estate. But what you are having to do is to whatever is the assets of the company which is there, hard assets, you are selling those hard assets and you are first going to make the payment to the PF because of the new judgment that you have to pay the PF dues irrespective of whether there is a separate PF fund or no. You have to nevertheless make the PF dues. So you are paying the PF. So who is you are paying from where? You are paying from the assets of the corporate. So which is realized by you. So that you can take a fee, in my view.
Yes, you have to take.
I don't know how IBBI is going to take this because they say PF dues are beyond 53. So that means even before your liquidation cost, you're supposed to pay
No dispute,
No.
dispute on that.
That is only if you have separate money.
PF fund is different, I think.
Madam.
It is already lying there. That cannot be done.
Hello, sir. In one,
Madam.
hello.
If you have separate fund, then only it is above 53. If you are realizing from the assets, then it is 53 only. You are entitled for both the realization as well as distribution.
Sir, I have one opinion. If it's a different fund altogether, that will not form part of the CD's estate because it will be a different trust or something.
Exactly.
Absolutely.
In that case only it is
not
above 53.
discussed in the judgment. Here, then the judgment, what they say, whether it's right or wrong logically, that is different issue. They say it is not the liquidator estate. Even the liquidator cannot middle with that amount. They say you get an assessment from the PF authority, whatever they demand, you pay them or allocate to them. You allocate the asset because they have the secured charges on all the assets of the CDs. So it's not identified to which asset it is. The madam's consent is that since they are not able to identify which is the specific secured asset, they have all assets, security on the all assets. So necessarily liquidator has to sell the assets, that portion of it covered by the PF, which we have to make the payment at the first on priority basis. So
you are saying that the fees cannot be taken on that part, is it?
That is what, because it is not form part of the 53 assets.
I have a different opinion. If the corporate debtor has not created a corpus and the liquidator is taking the efforts to create a corpus from the realization. In one of our cases, we had taken the fees on realization. Of course, we had not taken it on distribution because there was no distribution. We had kept it aside for the PF corpus. But in realization, definitely, I think we can take it. I mean, that's what we had done.
I think this is a practical concern and accordingly may be raised before the IVBI to have a better clarification on this part.
Yes,
It's a case specific issue. So accordingly, I believe that IVBI may clarify as to what should be done when it comes to liquidator's fee. Let us come to the next provision, which is reporting requirement. It says as to what all reporting liquidator has to do, what are reports the liquidator has to prepare. Of course, prelim report is there, asset memorandum, progress report. So just allow me a minute, just allow me to finish it off, and then accordingly we will take the suggestion of the respective members. So it says that sales report, minutes of the consultation committee, and then final report prior to dissolution to the adjudicating authority in the manner specified under this regulation. Here, the concern that we have noted particularly is with respect to this sub-regulation 3, which says that subject to other provision of this regulation, the liquidator shall make the report and minutes referred to as sub-regulation 1 available to a stakeholder in either electronic or physical form on receipt of so-and-so. So this particular provision allows the liquidator, requires the liquidator basically to share all its reports with any stakeholder. So there, say suppose if there are thousands of workmen, operational creditors, shareholders, etc. If anybody is coming and asking for a particular report from the liquidator, then pursuant to this particular regulation, the liquidator is bound to share those reports after receiving this undertaking. But in my view, that this particular this regulation should not be such open-ended. This should be restricted to the SCC members only and should not be open to all the stakeholders, as this may create a chaos and accordingly may disturb the liquidation proceedings, which we have also faced practically. Like any of the shareholders or anybody is coming up and asking for documents and reports prepared by the liquidator. So it becomes difficult for the liquidator to share the documents with the respective shareholders merely based on the undertaking of request. So I'll invite the views of the respective members as to what they think about this particular regulation.
I concur with you.
Is there any other views of any other members? So the suggestion here may be that
can you please repeat, ma'am?
So this sub-regulation part, if you see, this says that liquidator shall make the reports and minutes available to a stakeholder. So this makes very open-ended for the liquidator and at the same time mandatory to the liquidator as well to share all its reports, which the liquidator is required to prepare during the liquidation process with any stakeholder, because it says to a stakeholder. So any stakeholder, whether it's a workman, whether it's operational creditor, whether shareholders as well. So anybody can come up and ask for the documents or reports prepared by the liquidator.
This provision should be limited to the secured creditors only.
Yes, so this should be restricted to either secured creditors or stakeholder consultation committee rather than making it open-ended for any of the stakeholders to come and ask the liquidator for a particular report.
Yes.
Yeah, even in the SCC, all the members will be part of the committee. They say why somebody who is not sharing the expenditure nor able to realize his dues should be given an opportunity. Anyway, all these will be reviewed by the NCLT. So in that case, say why should everybody have an access to the proceedings?
Yeah, one doesn't know why one doesn't understand the rationale behind this amended regulation, this proposed amended regulation.
And there may be certain decisions taken by the liquidator in consultation with the SCC, or maybe for the reason or the circumstances arises during the liquidation process. Then a particular stakeholder may create hindrance or may disturb the liquidation proceeding after receiving.
It's like this. Yes, that is right. And it is like this. The liquidator is anyway consulting SCC. after SCC, just like COC, we are circulating the minutes. Also now, as per the amended regulation, certain agendas are being voted upon with 66% vote and all those things are there, right? So after that, what is the necessity of making, all these reports or whatever you're talking about? So there are 18 registers to be maintained. There are so many these things. Now, all these things, why should every stakeholder be given this? You restrict the number of things that the stakeholder can be given. Minutes is going to any stakeholder, everyone, whoever is now, everybody is in part of the SCC. So everybody is getting the minutes. What is the necessity? See, all these, all these registers, anybody can say, you please show all these registers.
Absolutely, sir. Absolutely.
So this is, I don't know, it's like, you are actually, IBBI is in some way, probably looking down on all liquidators as a class as cheaters or something like that. They're hiding something, they're doing something like that. This stinks. This actually stinks. This profession is becoming very disrespectful right now. They have actually kind of taken blanket ki everybody is a fraud of sorts. What is this? This is going
So
to.
I believe that that is the reason that suggestions been invited from us to contribute as to what all practical difficulty we are facing.
This is a huge difficulty.
So coming to the next regulation, which is about registers and records. So this says that where the books and accounts of the corporate debtor are incomplete, as on liquidation commencement date, the liquidator is required to complete the same and brought the same up to date, which is fine. However, the observations that we have made, particularly in this regulation, is about these registers that are required to be maintained by the liquidator. These registers and books, as may be applicable in relation to the liquidation of corporate debtor, the liquidator shall preserve these registers for 8 years. So these cash book, ledger,
tell me something,
bank ledger,
madam.
Should be reduced to 3 years. Should be reduced to 3 years.
Madam, another thing, when they say books of account of the corporate debtor are incomplete on the liquidation commencement date, the liquidator shall have them completed and brought up to date and shall, with all convenient speed, as soon as this thing, there is no timeline, thankfully, mentioned here. Now look at one case. I am the liquidator of Firestar Diamond International, Firestar International, Nirav Modi. Okay? Everybody is absconding. The records are all seized by Enforcement Directorate and CBI. So there is no record available. On one fine day, they all vanished. Nothing is available. How on earth am I supposed to bring the accounts book up to date, and what purpose will they serve? My second question is, if the company itself is totally dead, promoters are absconding, everything is locked down, what purpose will this exercise serve? Update the books for what?
Mr. Shantanu, before liquidation, CIRP date balance sheet has to be prepared.
सर ये तो CIRP में गया जब था ना, तब से ही तो सब attached ही था.
नहीं वो ठीक है, but it means RP has not prepared CIRP data.
He didn't have any access.
That's why I'm saying now, same thing. See, it's a general regulation and all depends upon case to case basis. When IRP has not made any balance sheet or any receipt payment for the CIRP date, then how the liquidator will prepare?
That is exactly what I'm saying. The thing is, when the whole case is gone case.
It's a general regulation. We have to see this regulation in toto.
Sir, in most of the CIRP cases, you will see that the books and records of the corporate debtor are filed for 2-3 years back to the commencement of the CIRP process. And of course, the RP is required to make that up to date. If RP is not able, then of course the liability is on liquidator. Now the concern arises as to how the liquidator will make the same up to date when there is no information available. So in order to give some comfort to the...
Let me speak something.
Yes, sir. Yes, sir.
In one among my cases, the books are not completed since 2011. the directors of the corporate debtor, they are all absconding. I have not been able to even catch hold of them.
Sir, your voice is breaking, sir.
Mr. Arora, then whatever data you had till 2011, then prepare till then and make a note of that nothing is available, so we cannot prepare. We are not God.
So maybe some kind of insertions may be made in the sub-regulation 1 as to based on the limited information, based on the information documents as available. So if that is inserted, then
or as may be applicable के जगह as may be practicable होना चाहिए. Applicable and practicable.
And also direction may be given to the committee of credit or consultation committee, members of consultation committee, etc., to cooperate with the liquidator and provide the necessary documents whatsoever they have available with respect to the corporate debtor to assist the liquidator to complete the financials. If something like that can be inserted here, so this will of course assist the liquidator to complete the books of accounts. And of course, will give some kind of relief to the respective auditor as well while auditing the accounts, because of course, auditor will also be in the dilemma as to how to proceed with auditing such accounts when the books and records are of such outdated.
And what about preserving for 8 years? That is also there, these records. When records itself is not there, how to preserve?
Sir, in later part of the regulation, this physical and electronic version of creating the documents or maintaining the documents is clarified, where it is said that in physical form you are required to maintain for 3 years only, and in electronic forms for 8 years.
8 years.
So this part is clarified in the later part of the regulation. However, the concern arises with this maintenance of register, which mandatorily required the liquidator to maintain the registers. Says that liquidator shall maintain the following registers.
Okay.
However, the concern is that when the company is already in liquidation, how many registers the liquidator will prepare regarding the tenant register and books of debt and outstanding debt, then register of fixed assets, securities and investment registers. What will happen to these registers? How is it possible for the liquidator to maintain all this huge list of registers when the liquidator is preparing the prelim report, asset memorandum, then the accounts are getting audited? And of course, when the auditor is auditing the liquidator account, liquidator's receipts and payments account, then they are auditing based on the respective vouchers or based on the respective proofs of the payment receipts and payments made by the liquidator. Then what is the need of the liquidator maintaining all these ledgers, bank ledgers, etc.? This will unnecessarily increase the task of the liquidator during the liquidation process. This is my view. However, the respective members may give their views on this.
The regulations may include a clause that say wherever possible, these registers are to be maintained. Wherever it is impossible or not practicable, then they should be given leverage to escort them. And I feel that the court should give directions to the enforcement authorities to make available the records to the liquidator so that they can update the records. They can build up the record.
What's been happening, sir, in my experience, now gradually the enforcement authorities are beginning to cooperate. But otherwise, even if a NCLT was giving any order, the enforcement directorate or CBI would typically go and file an appeal in the High Court, saying that these guys don't have a jurisdiction over us.
No, that is why the court should give directions in the code itself.
Unless the act
they should cooperate with us. Otherwise, how can we maintain or update the records?
Also, another thing what they say, I can give you, I have seized everything. What do you want? If you like in a Firestar case, this is I have 8 to 10 huge hard drives, You come, you take a backup of all that and you come to my office and you take it if you want. And I can just give you the dump. That's it. How you will take it, your cost. We can't just, we can't make it and give it to you. I said, okay, allow.
Okay, then you can take the dump and you can take the association.
That's what I said. I will come. Give me an appointment.
You can build
I said, you give me an appointment, I will come. Yes. That also they are not giving. Verbally, they told me that.
Can I make a suggestion, sir? Can we please keep the discussions short and crisp and related to the regulations only?
Sure.
Because it's very limited time and we have to complete the whole regulation today only.
Sure.
Coming to the next regulation, which
These
is
are all
about
technical
appointment
problems,
of
madam.
professionals.
Hello, Barsha, can we reduce the period to 3 years as discussed earlier?
Sir, it is provided in the latter part of regulation, as I said, as to what all documents the liquidator is required to maintain. I'll come to that part.
No, but here they are mentioning 8 years.
In this particular part, it is mentioned as 8 years. However, in the latter part of the resolution, sir, it is in the regulation, it is provided that the books and records of the liquidation process has to be maintained for 3 years in physical form and 8 years in electronic form.
Am I audible?
Yes, sir.
So I am saying even electronic form for 3 years.
So you are saying that that should be maintained for electronic form as well for 3 years only.
For 3 years, yeah.
I think what Barsha madam has now suggested that these all the books and registers they should be that should not be maintained. A suggestion should be given because the practical thing is going on is that one receipts and payments account are being maintained and by the liquidator, and at the end of the quarter it is being audited, and it is the purpose. So a proposal should be given to abandon these registers and books. If the company has these books maintained at the CRP commencement date, on the CRP commencement date, then it's okay.
So we have already discussed that part. Now coming to the next regulation, which is about appointment of professionals. So here the observations that we have is about that liquidator shall not appoint a professional under sub-regulation 1 who is his relative or related party to the corporate debtor or has served as an auditor to the corporate debtor in last 5 years. However, I believe that if the past auditor or the person who has served as the auditor of the company can be appointed at least to update the books and accounts of the corporate debtor as on the liquidation commencement date. So it will be easier for the liquidator to take it forward, as because the erstwhile auditor must be aware of the approach of the erstwhile management and how the books and accounts were kept prior to commencement of liquidation. So at least for up to date of the accounts as on the liquidation commencement date, if the erstwhile auditor can be allowed to update to assist the liquidator, that will be of quite help for the liquidator.
वर्षा यहाँ वो पर्पस नहीं है इसका. यहाँ पर्पस ये है कि liquidation commencement date, it's the responsibility of liquidator to prepare the balance sheet on that day. Right. Before that CIRP again, so it's the duty of RP to maintain the CIRP data. So liquidator has just to record the CIRP date balance sheet plus the CIRP data. Here the purpose of this regulation is not to appoint the existing auditor for the liquidation receipt and payment audit account, not the books of account of the auditor of the company, because there is no need under liquidation, there is no need to maintain the books of account of the corporate debtor.
No, sir, but the earlier regulation, as you have seen, that requires the liquidator to update the books and records.
Kindly mute this Rajendra Kumar. Yeah.
So the previous regulation requires the liquidator to up to date the books and records of the corporate. For up to dating the books and records.
Purpose is not to up to date the data of the liquidation commencement date. It is just to maintain the data till the liquidation commencement date, and there is no audit required for that. Under liquidation, you don't require to go for the AGM or pass the resolution for adoption of the accounts and all that thing.
No, while I understand that adoption of accounts and holding AGM, etc. is not required, but when it comes to up to dating the accounts, I'm not sure as to whether unaudited accounts will also
I have handled around 8 liquidation matters.
So whether the respective
there is nowhere required for auditing of the books of account of the corporate debtor.
All right. So apart from that, I personally don't have any observation in that regulation. Coming to the next part, which is about consultation with the stakeholders. So it says that stakeholder consultation shall be extended to the liquidator, which is of course in favor of the liquidator, and then liquidator shall maintain the particulars of consultation. I do not find any particular observations here.
This is absolutely fine.
Now coming to the next part, which is personal to extend cooperation to the liquidator. Again, this one is in favor of the liquidator only. So again, I don't find any.
Regarding updation of books of accounts, if the IRP has not completed the audit of the up to the date of CRP date, then whether liquidator is required to audit the same and file it with ROC.
In my view, the requiring to up to date the accounts of course is required, but filing the same with the ROC is not mentioned in the regulation. It is not clear in the regulation. And again, as Pankaj has said that he has not audited the accounts of the respective companies which were going liquidation. It was merely to update the accounts only and not to get the same audited, etc. So,
Do you see
So this is, hi, just one point here. I'm Shalini. So I don't think the liquidator has to do the audit himself. They can appoint an auditor, and that
which is correct that
auditor
audit has not, liquidator is not required to do audit. It is very clear.
No, so it was mentioned now that the liquidator has to audit. So I'm just I just want to put one point that the liquidator can appoint even the previous auditor to bring the accounts up to date. I don't think that is covered in this, list of professionals appointed to assist the liquidator to perform his liquidation tasks.
Liquidator cannot appoint the previous auditor. Even the disciplinary action of the IBBI has taken in one of the matter.
So this was my observation here, that in one part, the liquidator is required to update the books and accounts, and the next regulations restrict the liquidator from having the existing auditor of the company to audit the books and records of the corporate debtor. So if that liberty can be provided to the liquidator.
For this specific task, it should be allowed. Just for the purpose of bringing the audit up to date, duties of previous or services of previous auditor can be taken. That can be one of the suggestions if the forum agrees with it.
Coming to the next part, which is about personal to extend cooperation to the liquidator. Again, I don't find any issue or any observation in this particular regulation. If any of the members have any observation in this
Nothing.
extension, then.
One suggestion under regulation 9, we can mention the DM or SSP or police officer, whosoever it may be. Like in CIRP, we have mentioned regulation 9. So here also regulation 9, we can do this.
In which particular part you are saying, sir?
Regulation 9,
okay.
Operation to the liquidator.
Mm-hmm.
Administrative officer and
administrative officers, right?
And police officers word can
absolutely, absolutely. Then coming to this disclaimer of onerous property, which says that where any part of the property of the corporate debtor consists of such a kind of properties like shares, stocks of a company, unprofitable contracts, etc., then liquidator is given the liberty that he has the endeavor that he may say that he has extended all the endeavors to sell such kind of assets of the property or exercise all the acts as required to be done, and accordingly can make an application with the adjudicating authority within 6 months from the liquidation commencement date to exclude such a property to disclaim such a property from getting it realized, etc. So if at all anybody has any particular observation here. Merely apart from this timeline of 6 months, I don't see any particular reason to make any observation here or any particular observations I personally don't have. So I'm moving towards the next regulation. which is about extortionate credit transaction. Again, in this regulation, this is all about the application required to be made by the liquidator regarding such a transaction. Then next regulation is about public announcement to be done by the liquidator, which requires the liquidator to make the public announcement within 5 days. And then public announcement.
Increase the period to 7 days, as we discussed in CIRP.
The period should be extended to 7 days.
7 days. Yes, 7 days.
No, 5 days. I think 5 days is sufficient, but we can make it from the date of the receipt of the order.
Yeah, clarity in that regard may be provided,
Yes.
because often it has been seen that even the order is pronounced, however, the liquidator gets the order in hand at a later date, and then
Exactly.
it gets confused as to what date should be taken as a date of commencement of liquidation process. So of course, or making public announcement. So of course, this clarity should be inserted here. And then next, which says that the public announcement shall provide that where a stakeholder does not submit its claim during the liquidation process, the claim submitted by the stakeholder and duly collated by the IRP or RP, as the case may be, during CIRP process shall be deemed to be submitted under section 13. Here in the last discussion as well, we have discussed that when the liquidator is required to accept the claim which was submitted at the time of CIRP, then again the confusion will arise as to whether the same claim has to be taken as on the resolution commencement date or CIRP commencement date, or the same has to be updated as the liquidation commencement date. Because say suppose if a creditor has submitted a claim during CIRP, and after commencement of liquidation, or the period for commencement of liquidation took, say suppose, a year or two, and the particular creditor has not submitted its claim during the liquidation having regard to this particular regulation, and says that I have already submitted my claim at the time of CIRP. Now you add on the interest and then update my claim as on the liquidation commencement date. So this will not be possible for the liquidator to have it updated as on the liquidation commencement date. And accordingly, this liberty should be given to the liquidator that this claim should be, if the particular creditor is not submitting claim during the liquidation process, then the claim as on the CIRP commencement date as submitted by the creditor during the CIRP process has to be accepted by the liquidator without making any changes.
It should be the bonus of the creditor to update the claim as with the latest interest and all that. It is his duty. It is not a duty of the liquidator.
But sir, given this particular provision which has been inserted in the regulation, now it has become a duty of liquidator to accept the claim.
It should be amended, sort of.
No, it's the duty of
the burden.
Sir, with due respect, it's the duty of the liquidator to verify who has filed the claim during CIRP and who has filed the claim during liquidation. If any person has not filed its claim during liquidation, then from the data of the CIRP, liquidator has to intimate to that person, see, now liquidation has started, you have to file the fresh claim. It is onus on the liquidator.
That is right.
So, yeah.
What I'm telling is that as a updation of the claim where the claim is not raised by the
during that same thing I am saying, if any person has not filed claim during liquidation, but they have filed during CIRP, then it's the duty of the liquidator, rather onus on the liquidator, to intimate them that now liquidation has started, you have to file a fresh claim.
Pankaj, are you saying the liquidator has to individually intimate each creditor who has not filed?
Yes, sir, it's the onus on the liquidator.
But the regulation,
the claim will be, claim submission period will be over by the time the liquidator knows that who are all have filed the claim. So thereafter,
sir, I am sorry. At this point, I am sorry. It's 30 days period has been provided to verify the claim.
Yeah, after 30
right.
days,
And on the very first day, liquidator take all the data from the RP. In 90% cases, RP are the liquidator. But if liquidator has changed, then it's the duty of the liquidator to, on the very first day, to take over all the documents from the RP and see who has filed their claim, just to intimate them that now liquidation has started. This is the order.
But Pankajji, the regulation is providing that if the creditor is not submitting the claim during liquidation, then his claim submitted during the CIRP process shall be deemed to be submitted under Section 38. So where is the question of the liquidator going after each and every creditor individually?
To avoid, Atulji, to avoid unnecessary litigation or later stage. Otherwise, after 6 months, that creditor will pop up and say ki you have admitted my claim till CIRP date, and CIRP has gone for 3 years. My interest has accrued on this amount.
Then you mean
So,
out of caution we can do that.
Yeah, but I think,
particularly to avoid any unnecessary.
Just one point. I think this regulation deals with the case where even after liquidator may be bound to ask everybody to file, but even if they don't, then this regulation provides for the liquidator to take the claim as given during CIRP as the liquidation claim.
Bound to ask in the sense you're saying send a mail to everyone. Does it say that?
No, I'm not saying that at all. I'm saying that even if you take Mr. Pankaj's view that liquidator is bound to ask, even then some people may not reply. So this regulation covers that situation where liquidator is not getting any response. Then he can take the same claim.
That's right. That's
the duty of
that's
the
our understanding
liquidator.
also.
It's the duty of the liquidator to intimate all. If they had not updated the claim within due time, then CIRP claim has to be admitted.
By intimating all, you mean to say
Newspaper advertisement is for that purpose only, na?
Sorry?
Yes, so for
Advertisement has already been
it is not
published.
required to send individual mails. It is the public announcement itself suffices.
Public announcement is already there.
Yes,
Then
public
public-
announcement, website
then
announcement, announcement at
public
IBDS
announcement
portal
is
will
already
suffice.
there, but
on
in many
website also.
yes, but in many cases, even NCLT has taken a reverse view. Why you have not intimated them? So that's why on the safer side, to safeguard the oneself, if we comply with this provision which gave mail to everyone along with the order of the liquidation, what harm in this?
No problem.
Small cases, of course,
can
it is
do
not
that.
a problem, but in huge cases where there are thousands of workmen and then thousands of operational creditors, etc., it will practically be not possible. So this should, I believe that they should keep open for the respective liquidator.
Yes.
And of course, the clarity should be provided when it is required to the liquidator to take the claim submitted during CIRP process. So the clarity should be required. The clarity should be provided in the regulation itself, that the claim as on the liquidation commencement date has to be taken in that cases where the particular creditor is not submitting for the fresh claim during liquidation process.
I further wanted to submit so that the onus of updating the claim should not be on the liquidator.
Should not be on the liquidator.
At this CIRP time, as Pankaj is saying, 3 years have already gone. So why liquidator should be calculating the interest and adding on when he is not aware of his right and he is not coming forward.
Coming to the next regulation, which is 12A, which provides for a process email ID. I do not find any issue in this because this particularly requires the RP to hand over the email ID that he was maintaining to the liquidator. And then coming to the prelim report as to what all should be included in the prelim report. Again, I do not find any issue in this. If anybody has anything to submit in this prelim report part, may please say. Okay, so I'm moving to the next, which is about early resolution.
Regarding the email ID, which you're telling that the RP is supposed to hand over it to the liquidator, which he was using. So in my case, what happened, they had taken the services of IPE. Okay, and it's like Deloitte, okay. So there they had multiple email IDs under which they were dealing with the CIRP process. So they were not willing to share the email ID at all. And they said it is for like, everything ends with @deloitte.com, @deloitte.in. So obviously they will not be able to share it with us. So this email ID, I think some amendment has to be made wherein they should say that it has to be like a Gmail or Yahoo, which can be passed on to the liquidator.
Well, I believe that that particular clarification is not required at all, because now this regulation mandatorily requires the respective RP to share the ID. If the RP is reluctant to share the ID which he has created for the purpose of CIRP only, then at the very inception itself, the RP should be cautious while creating such an ID, so as to have it clear that at the end of the process, if the RP is not continuing as a liquidator, then RP has to hand over the ID to the respective liquidator, no matter what, no matter it pertains to the deloitte.com or whatsoever.
After this regulation came in, now the IDs are being made like that only, which is general in Gmail and things like that.
Yes, and this has been created recently itself. So
Madam,
I think that the respective RP will have clarity henceforth that they have to create a separate ID rather than creating a domain ID which they cannot share otherwise.
Madam, I have got a suggestion. Say the liquidator may be asked to certify that a separate email ID is created for the purpose, and he should further undertake to pass on this mail ID to the next liquidator if appointed, if any. So
Sir,
that he will
if
become
you can
aware that
elaborate this a bit as to why you are suggesting this.
Pardon? So that the problem faced by the other colleague may not be repeated in future.
So the idea behind this is that because mostly all the claims, then all the communication with the stakeholders, whether it is a communication with the bankers, etc., everything is in the particular ID. And since the liquidator has to carry forward with the process, hence the ID should be handed over to the respective liquidator, so as to have it clear to the liquidators to what has happened in the past during CIRP process. Coming to the next regulation, which is progress report, this says that liquidator shall submit progress report in the format stipulated by the board to the adjudicating authority, and board shall be substituted as under. So this part I don't understand as to why this part has been included. Maybe there's some typo error or such, because the inverted comma ends here, but the beginning of inverted comma is not there. So it is merely a typo error, nothing else. Apart from this, in the progress report as well, I don't see any requirement. Just one suggestion from my end is that after filing the final report, no progress report is required to be filed. This should also be inserted very clearly, as because it is seen that after filing the final report or dissolution application with the NCLT, the liquidation process continues for 2-3 years. So whether the liquidator is required to report anything as to what is happening.
We are filing the report today.
So
Today we are filing.
Because we have not filed any progress report after filing the final report. I am not sure as to what practices other professionals are offering.
I am filing. I have a case where more than 1 year the dissolution application is still pending. Another practical problem that I am facing now, in 2 cases I have filed the dissolution application. This is one suggestion I had emailed to our IPA also. Now, what the NCLT is saying, that you first close the bank account, liquidation bank account, get a certificate that you have closed the bank account, then I will pass the dissolution order. Now, let's say in one hearing he has said that. After that, it takes another, I close the account, it takes another 10 hearings or 10 dates to finally pass the dissolution order. If I have closed the account and I've distributed everything, and where will I pay the legal fees from? My
so
pocket.
I'll just quickly answer your query in this part as to how practically we are handling this issue. We are keeping a part of the available fund in the liquidation account aside before making the distribution, and accordingly taking approval of the SCC or the consultation committee or the contributories, as the case may be, before keeping that part aside to meet the expenses till the dissolution of the company, till the company is getting dissolution.
No, in which account are you keeping it?
Separate account of the liquidator, in the liquidator's account itself, personal account of the liquidator. Keeping
Personal
that amount
account
aside and keeping a track of the entire expenses to be made from that particular fund which has been kept aside, and also making a confirmation in this regard that as and when the company is getting dissolved, the entire remaining amount after making the expenses will accordingly be distributed to the respective contributories or stakeholders as the
No,
case.
that is right, but that is exactly what it says also,
That
the
should be
regulation. But if you are taking it in your personal account, mind you, it comes as the income. You will face problem in your personal income tax.
Or reimbursement, the same may be
Okay,
treated
so
as reimbursement.
basically, if the regulations specify that the NCLT shall pass the dissolution order, okay, and direct that the liquidation account be closed, all the disbursement made, and a final report filed within 15 days of passing the dissolution order in form of an affidavit with the NCLT, that should be the way forward. Because what happens is like you rightly said, even after filing the dissolution application, the various matters goes on. In one case, I had a new IA coming in against the liquidator by a government authority. All of a sudden waking up. And they actually went to NCLT. When I told them, I have already filed the dissolution application, they went to NCLT, but I had to then hire a lawyer, no? So that fee has to be paid. Now, if I had closed the whole account, how am I supposed to pay the lawyer's fee? And if I keep it in my own account, then I will have a problem.
The probability of treating the same as income arises.
It definitely arises.
Sir, after dissolution also, we have no power to operate the liquidator account. The bankers are saying you have no power, even for RP is this one, once the period is over, they say you have no power to close the account. In the order, there is no specific mention about the closure of the account like that. So the same issue will come even for closing the bank account itself.
No, that is what I'm saying. The order should say.
No. Shantanu, it's not practical. See, at the time of dissolution, filing the dissolution application, you have to submit the Form H, where you have to, along with the final report, where you have to also attach the audited accounts, receipt and payment accounts of the liquidator. Right? So, in best way, which I follow in my cases,
right,
under the with the SCC, permission of the SCC, we fixed a cost of litigation for dissolution. Suppose we fix the cost of 2 lakh rupees for following up the dissolution application. So we did not charge that amount from their account, and after the dissolution, from the all stakeholders, whatsoever contribution percentage of contribution there, we took that expense from the individual stakeholders.
So then you have to run after them to give you the money.
Why to run after it? I also mentioned under the minutes of the stakeholder committee consultation meeting.
But how, you have always been able to recover from the banks?
Yes, yes.
But practically, it has been seen, sir, that in many cases, the SCCs are not cooperating after getting the final disbursement.
In my case, I never faced such issues.
We have faced these issues in our cases, and what approach we have taken is to keep aside a minimal amount based on the estimated expenses.
But you cannot file the dissolution application without closing the liquidation account.
No, that is what I'm saying, that keeping a amount aside in the liquidator's account as a reimbursement based on the estimate, taking the consent of SCC,
Yes,
closing the account.
You can do like this also, and monetize that in your last stakeholder.
In that case, sir, what will happen is the ball will be in the court of the SCC, and you have to chase the SCC for every payment that you are required to do. Says you are required to appoint a senior advocate, or you are required to make this printing, stationery expenses, etc. Every small expenses you have to approach to SCC.
Yes. That's why
so that is a difficulty.
That's why I'm saying in last meeting of the SCC, after selling all the assets and after distributing, it's the best judge is the liquidator who will analyze what litigation are going on and what estimated cost shall be there.
Okay, coming to the next regulation, which is about submission of claim. So it says that the stakeholders required to submit the claim as on the last date of public announcement, as mentioned in the public announcement. Here again, I believe that there should be some restriction on the stakeholders who have not submitted a claim within a particular given time, because it is seen that even after 2-3 years of commencement of liquidation, the stakeholders are coming and filing their claims and then going to NCLT with section 42 application. which is unnecessarily burdening the NCLT benches with these kinds of application. So either the liberty is to be given to the liquidator to adjudicate the claim which are submitted subsequently as well. And there should be a fixed timeline as to within this time, if some stakeholders are failed to submit their claims, then they will not be allowed to submit their claim at a later part as well. There should be some restriction on the stakeholder to submit their claim instead of allowing the stakeholder to submit their claim to till the dissolution of the company. Then coming to the claims by the operational creditor, the claim parts when it comes to operational creditor, financial creditor, workman, etc. I personally don't have any observations here, but if any of the members have any observation in claim submission format, may please give their views. Okay, then moving towards this proving of security interest, which is regulation 21. It says that the existence of security interest may be proved in either of these ways. So there are three ways which are provided to prove the security interest. Now again, the concern is with respect to government's dues. As we all are aware that based on the rainbow paper ruling, now government dues are also required to be treated as secured creditor. Then how the security interest will be analyzed in that part? How will we determine as to what particular asset the government has security interest? If at all we are required to adjudicate the same, on what basis we will adjudicate, etc. Because surely they are not going to provide these details.
This is not being in the this regulation is not providing that.
No, it is saying that security interest may be proved in either of the three bases. So there are three bases which are provided for the security interest. When it comes to secured creditor has to have a security interest. If the government is treating itself as a secured creditor, then on what particular basis the security interest has to be determined?
That's right, ma'am. So that has to be provided in the regulation, I suppose, no? Because it is not presently.
So that is what I am also saying, sir, that it is presently not provided, and hence the liquidator currently, as of now, are facing difficulty. However, if later part, if IBBI comes up with a clarification, surely this part will also be covered. Then coming next to the presumption of security interest, again, I do not feel any part which requires amendment. However, the respective members are requested to submit their comment if they have any on this presumption of security interest part. Then production of bill of exchange and promissory note. Again, substantiation of claim, the liquidator may call for such other evidence or clarification. Again, this is in favor of liquidator only and do not require any clarification in my view. Coming to cost of proof, again, it is very, very clear that who should bear this cost of proving the claim in the regulation itself. Then determination of quantum of claim, whether the amount claimed by the claimant is precise due to any contingency or any other reason, the liquidator shall make the best estimate of the amount of the claim based on the information available with him. But it is seen that the stakeholders are making application before the adjudicating authority against the decision taken by the liquidator. So if at all any of the persons, any of the respective members have any comment to say based on the practical experience, they may please mention that. Okay, moving towards the next, which is debt in foreign currency, then periodical payments, then debt payable at future time. These are the regulations which in my view do not require any further clarification and are cleared. Then mutual credits and set off. Again, this is also not required any clarification. Coming to the verification of claim part, it says that provided that liquidator shall also verify the claim collated during the CIRP process, but not submitted during liquidation process. Here the concern arises that if a claim was submitted during CIRP process, the same was also verified by the respective resolution professional or IRP, and only 30 days time has been given to the liquidator to verify the claim. And how is it possible for the creditor to verify the claim which were submitted in the CIRP process? Because it may make the task of the liquidator a bit cumbersome, as this may require to bifurcate the claims. Some claims were submitted during CIRP, and those creditors may have again repeatedly submitted their claims during liquidation process. So first to bifurcate as to whether this claim was submitted during CIRP or not, and then if the claim was not submitted during CIRP, then to accept the claim which was submitted during CIRP process and to verify the same within the period of 30 days. So it may make the task of the liquidator a bit cumbersome. So if the clarity will be there that the claim which was submitted during CIRP period, as on the CRP commencement date, has to be accepted by the liquidator as is or as accepted by the resolution professional, and the liquidator is required to verify the claim submitted during the liquidation process. So the liquidator's task will be limited to verify the claim which are submitted during liquidation process and to accept the claim as was verified by the resolution professional.
But there is one problem here. They will say that liquidator is supposed to adjudicate, whereas resolution profession is supposed to collate. You know, so that
Yes.
difference will always come. Somebody can turn around and say that you know, it was liquidator's duty to adjudicate. Maybe instead of the 30 days, this who have not submitted during the liquidation period, but had submitted during CIRP period, maybe another 30 days can be given.
So your observation is very correct that of course during the resolution professional do not have power to adjudicate. However, the question of adjudication arises only where there is no synchronization between the claim submitted and the claim admitted by the respective resolution professional. So this may again be limited to such claims in which adjudication is required. If the claim are clear or accepted by the resolution professional, then in that case the intervention of liquidator is not required, in my view.
Oh, one minute, madam. Hello.
Yes, sir. Yes, sir.
Sir, madam, the CRP date is February 21. Liquidation date is 22 May. Recently, I was appointed as liquidator in that case after expiry of the erstwhile liquidator. Now, recently, I had received a claim from income tax, 88 lakhs, which he has not submitted in CRP liquidation also. Hello?
Yes, sir. Yes,
Hello?
sir. Please continue, sir. You are audible.
Number one. Number two, that claim was disputed by the management, erstwhile management. They had filed appeal also. Now, number two. Number three, I was sent a mail. This was not within my purview for accepting of the claim after 2.5 years. I sent a mail to the income tax authorities because this is not within my domain for accepting the claim at this juncture. Third. Fourth, what is the next step to me? Any advice?
Once the delay is condoned by the adjudicating authority, after that, of course, you will have to verify the claim as submitted by the income tax department. And after verification, while condoning the delay, of course, the bench will also see the amount of claim or the manner in which or the documents based on which the claims have been made by the income tax department. If the delay is condoned by the bench, then you are duty bound to accept or to verify the claim. If at all you are rejecting the claim, then again you have to record the decision as to why and on what basis you are rejecting the claim. So this is.
And one more thing, madam. The claims belong to 2016-17. CRP commencement date May 2022. So as for section 53, only 2 years claims only. Government is only 2 years, na?
So that is you are talking about based on the Rainbow Papers ruling, I believe.
No, I am not talking. As for section 53, I am talking.
Yes.
So as for section 53 waterfall mechanism, any central government, state government is only 2 years prior to the commencement date of liquidation. My claims is belong to 2016-17. How I can accept, madam?
You are very much right. But I think, Mr. Gowda, we should move further and we can discuss this on private basis because it's not the agenda of our today's.
Okay, thank you, sir. Thank you. Kind enough.
Okay, so we are focusing on this liquidation regulation today. Let us move ahead with the further regulation, which is regulation 30A. It says that transfer of debt due to creditor, which is regulation 30A, which allows the creditor to transfer its debts or assign its debts So again, I do not see any particular observation in this part. Then list of stakeholders, which says that a liquidator is required to prepare a list of stakeholder on the basis of claims collated by it. And there's a timeline given for preparation of the list of stakeholder.
So, madam, one question which was raised about the disputed income tax portion. What would be the treatment as per everybody's views on that?
Ma'am, as we said that today we are focusing on liquidation regulation part only. So let us first freeze this liquidation regulations observations. And then of course we will take up this practical questions, which certainly for the time being is not related to this liquidation regulation. We will surely give our views after completing with the review of the necessary.
Okay, sure. Yeah, please go ahead.
Regulation. Then this list of stakeholder, it says that the liquidator shall file a list of stakeholder with the adjudicating authority within 45 days from the last date of receipt of claim. And in the later part of the regulation, which is about to preparation of the stakeholder or the constitution of the stakeholder consultation committee, it says that the liquidator shall constitute the consultation committee comprising of all the creditors of the corporate debtor within 60 days from the liquidation commencement date. So here it says that 45 days after the last date of receipt of claim, it says that the liquidator shall file the list of stakeholder with the adjudicating authority within 45 days from the last date of receipt of claim. And the timeline for submission of claim is 30 days. So if we add on this timeline, so it becomes 75 days here to submit the list of stakeholders. SCC has to be prepared based on this list of stakeholders only. However, this says that the subsequent regulation, which is about constitution of SCC, it says that SCC has to be constituted within 60 days of the liquidation commencement date. So if the same, either the meaning of this regulation can be treated as the list of stakeholders can be submitted at a later part or after constitution of SCC, or if we require to sync the same, the same has to be synced in line with the regulation. Then accordingly, the timeline for consultation, the timeline for constitution of the SCC has to
must be 75 days.
Should be 75 days. Then coming to the next part of 31A, there are several discussions that we had earlier as well in this SCC regulation, the regulation 31A. As to first part is what all discussion is required to be done with the SCC. This particular regulation requires SCC to discuss about fees of the liquidator, then valuation, then the manner, etc. So the concern that arose earlier as well was that whether the power of SCC is limited to advisory or is also of decision making. This should be clear, because given the exposure which has been given to the SCC, it seems that the power is slowly moving towards the decision making procedure. So this part has to be cleared. Coming to the next part, it says that the voting shares of a member of consultation committee shall be in proportion to the admitted claim in the total admitted claim. So does it require or does it permit the promoters or the directors of the company as well to submit their claim, shareholders of the company as well to submit their claims? A clarity in this regard is also required, because it has seen that in many of the cases, the shareholders are participating and they are also saying that pursuant to this particular provision, they have the right to participate. So whether a clarification in this regard is required, members may please give their views on this.
An authorized representative representing the shareholders may participate in the meetings.
So a clarity in this regard should be there, that who all should not be given any voting rights.
Otherwise, wherever there are a huge number of shareholders, it is impossible to accommodate them.
And moreover, as far as the creditors are concerned, they may still define their amount of dues by virtue of the agreement, loan agreement and all. Whereas as far as the equity shareholders are concerned, how can they come to arrive at a claim amount, by the way?
Because here we see that in this particular part of the provision, it says that promoters, directors, partners, etc., they have the right to attend the
Correct.
meeting of consultation committee, but they do
Absolutely
not have
right.
right to vote. In the
They-
subsequent part,
Problem here is during CIRP, the promoters, directors, their powers are suspended. Whereas the liquidation order says they are discharged. Now, after they are discharged, what is their right or what is their locus to attend such meetings? What is it that they will do? You know, what are they expected to do?
One thing, sir.
in such a meeting?
They can
Yeah.
only give suggestions.
One thing. As for the
Yes.
regulations, on behalf of shareholders, one may be allowed. One representative may be allowed without any voting rights. That is the
How will-
regulation says.
That
Yeah,
is
how
old
will
regulation.
you how will you determine? Let's say there are thousands of shareholders. Okay.
One only they will represent. Otherwise, we cannot take. Because what regulation says, on behalf of shareholders, one may be representative. Who will decide if they are not coming? We can ignore, but we cannot. We are not taking into consideration. That is the violation.
Just in the case of home buyers, they may be given a choice of among three authorized representatives who may be chosen by the shareholders, and he should represent the entire class of shareholders or debenture holders or preference shareholders, etc. out of the class B.
My point is when the company is into liquidation and the shareholders will only be entitled to if there is a surplus left after settling all the claims, right? So in that circumstances, promoters as a shareholder or any shareholder for that matter, how is he affected by the liquidation process? You know, rather than, if you allow them in, all that I can see is future litigation saying that liquidator is not selling it at the right price and X,
Mr.
Y,
Ray,
Z.
Mr. Ray, in my
G.
view, sorry to disturb you, in my view, this shareholder has been included for the large listed corporates, where shareholder felt that they have been ditched by the promoters, and
Okay.
their representation has not been made. There is no provision for the retail shareholders during
Okay.
CIRP.
Mhm.
So during liquidation, this shareholder has been added.
No, but tell me something, the shareholder ultimately will get anything only after all other creditors are satisfied and there is surplus.
That's true,
right?
that's true, that's
तो
true.
अभी
But see,
वो जो उल्टा
listed-
उसने अगर रिप्रेजेंटेशन देना था वो तो सीआईआरपी में देना चाहिए था
नहीं सीआरपी में उनको
लिक्विडेशन में देके क्या करेगा
हाँ सीआरपी में उनको इंक्लूड ही नहीं किया
वही तो मैं
in
बोल
the
रहा हूँ
same
तो
in
अब
the
करके क्या
same
करोगे
way in the same way during CIRP under list for the listed company at least 5% share for the retail shareholding has to be reserved.
that is for if there is a resolution plan.
Yes,
But
yes,
अगर-
during resolution
हाँ,
and during
but अगर-
CIRP during liquidation in the same way it is for the large public listed company to safeguard their interest. They have included the shareholder rights.
But in what manner is what I'm
Sir,
asking.
Pankaj
If there
sir,
is
can I
please.
tell something?
Yes, please.
One second. The shareholders are not in the stakeholders committee as per the amended regulation. That was there earlier only. Now he is there, is not there. What is mentioned is promoters may participate in the committee meeting, but they have no right to vote. It's only for promoters to just come and participate if necessary. They may participate. We are not supposed to call them for every meeting. So shareholders have no role to play. They are not part of the
There is ambiguity in this regulation itself. Kindly read the first line. Provided that the promoter, director, partners, or their representative may attend the meeting on the consultation of the consultation committee. but
Yeah.
they had not mentioned the shareholders word.
Yeah, that's what I'm saying.
Right.
Shareholders
And-
are not part of it.
And under sub-regulation 3, they have mentioned the shareholders words. So there should be in alignment of the whole regulation. So I think there should be some amendment in the regulation to align the shareholders in the proper way.
I agree. It is very confusing.
Yes.
It
So
has
the
to be
concern was
set
arise
right.
only because of this reason, that here in regulation 3, it says that the liquidator may facilitate the stakeholders of each
Exactly.
class, and this includes shareholders and partners.
Exactly.
Subsequently, regulation 4A says that representative under 3 and 4 shall vote in proportion to the voting shares. So this
Yes.
has, because of this, confusion has arisen, and accordingly a clarification
So
may be
it
provided.
means as per sub-regulation 4, it means shareholders can vote.
That's what it means. But
Looks like-
is
Yes.
that the intention?
Yes.
Is
yes,
that the
yes.
intention?
Yes. So that is
But
my.
then what is the shareholders' claim? Proportion to their claim. What is the shareholders' claim?
Sir,
That is
whatever, sir, their
It's-
claim is their shareholding.
No,
How
shareholding
do
is
we
face
decide?
value. Face
How do
value
we
or
decide?
market value.
What is the value you ascribe to that
By
shareholding?
value.
Sir, sir, face value, face value.
Face value, face value.
No,
Face
sir.
value.
Look at the number of shares held by them.
Yes,
Sir, if
number
it
of
is a
shares held
listed
by them
company-
multiplied by the face value.
But
But
if
that would be a very simplistic
face
way
value
to
does not
value.
have
Yes,
any
yes,
role.
yes.
Here the value has been totally eroded.
Barsha ji, kindly note down that we required some amendment in this regulation.
Correct.
Right, sir. So I have noted down the amendment as of now that has been proposed by the respective members. And given that we have already closed 2 hours for today's discussion, unfortunately, I have to close it for today. And if members permit, we can continue this on Saturday. And along with this, the observations on voluntary liquidation regulations as well, we can continue on Saturday if members permit. And if, of course, the same is suitable to ICSI IIP to have the
Same-
discussion on.
Yes,
Would be
yes.
same time 4 p.m.
Fine.
Next
Same
Wednesday.
4
These
4 to 6.
SEC guidelines should be reversed to the other position.
Okay,
Say,
so is 3 p.m. or 4 p.m. is suitable?
Madam, take it for next Wednesday.
Sir, next Wednesday we have other regulations scheduled
Yeah, you
up. so
can,
we have
yeah, you
to
can postpone, you can postpone one session or do some adjustment and
Yeah, I agree.
Just continue. It will
Okay,
be
so you want
convenient.
it on next Wednesday only.
Yeah.
We can go on Saturday. No, Saturday evening we can complete.
program is there, madam.
When are we supposed to, when are the IPS supposed to finally give their submissions to the IBBI, Nitika?
Sir, after the end of the entire series, like for the CIRP regulations, we have already closed. The minutes were already shared. And then for liquidation also, we will share the minutes with all the participants. But the consolidated report will be shared after the conclusion of the entire webinar series.
Okay.
So I
will have
believe
it on
that
Saturday.
ICSI
Nothing
may
wrong with it.
accordingly, in discussion with the participants, can decide as to on what date, next date we should discuss about and close this liquidation regulation and also
Yeah,
the
okay.
voluntary liquidation.
Saturday also is okay, no issue.
On Saturday, okay, madam.
Saturday also okay.
Saturday also we can discuss. Maybe same
Saturday
time,
one
4
more
o'clock.
program is there.
3 o'clock, 4 o'clock Saturday.
The Saturday, some other programs, webinars are there already.
Okay, let's do one thing. We can have the liquidation and voluntary liquidation on next Wednesday. We will postpone the last Wednesday session on the next Wednesday thing. So we'll
Then
have.
we can extend by 1 more week.
Okay.
One extra
Yeah,
Wednesday we
we
can carry.
1 more week.
Session
We'll
we
leave
will
the
have
Yeah, yeah.
That should
Out.
be better.
the brochure accordingly.
I mean, you say instead of 9, it will be 10.
Yeah, it will be 10.
Fine.
Thank you. Fine.
Fine,
Thank
that's
you.
nice.
Thank you, everybody.
Thank you so much.
One more CP. Thank
One
you.
more CP.
Thank you.
Thank you.
And thank you. Very nice session.
Thank you.
Thank you.
Thank you. Thank you very much. Thank you very much.